Welcome everyone to the first iteration of the 2024 King's Young Professionals. Today I'm going to be talking about amendments made under Part 17, under the rather pithy name, New Year, New Statement of Case. So first as an introduction, what am I going to do today? Well, today I'm going to talk to you through the key practice points to keep in mind when making a Part 17 application. And I'm also going to highlight the key principles that the court applies. The structure, which we're going to apply in the next 25 minutes or so, is firstly, we're going to look at when permission actually is required. Secondly, if it is required, how do you go about getting that permission? What's the procedure that you go through? Thirdly, when you're making that application, what are the principles that the court will apply? And we will also be focusing on late applications. I'm going to have a quick discussion about costs, which is always at the forefront of everyone's mind when making these applications. And then we'll have a quick mop-up at the end. What I'm not going to do is I'm not going to overwhelm you this morning with case law citations or reference to illustrative decisions. This is an area replete with examples. And it's not going to be in anyone's benefit for me to spend half an hour simply reading out what judges have said in particular cases. Nor am I going to talk about amendments where limitation is an issue. I do like to leave these talks on a bit of a cliffhanger, so no guesses as to what might be coming later in the series of King's Young Professionals. And then coming to the third point on the introduction, why might you be making an amendments application? This can be for a whole host of reasons. It may be that there's been an oversight and you want to correct an error in the pleadings. It may be that further things have happened since you first issued your claim and you're looking to amend your claim to bringing in a new cause of action. You may alternatively be looking to amend to add new parties to the proceedings, to substitute in or remove parties. And then fourthly, something that is often overlooked, I find in practice, and is something that you should be keeping in mind if you're the respondent to a summary judgment or strikeout application, is that the Part 17 mechanism can be a useful tool if you find that the other side say that your case doesn't meet the thresholds for litigation and they try and bring those proceedings to an early end through summary judgment or strikeout. So, turning to the first point, is permission actually required? Because of course, if permission isn't required, then everyone's happy and we can just crack on with making the amendments and proceed through to the next stage of the case. Rule 17.1, I've referred to Part 17 already. That's where all of the rules regarding amendments are to be found. Rule 17.1 sets out the three instances where you find that permission actually isn't required. The first is in an instance where you have filed your statement of case with the court, but you haven't yet served it on the other parties. And the rules are quite clear. You don't need permission from the court to amend in those situations. The second is, and this is tied in to Part 38, but if you're seeking to discontinue part of your claim, you want to proceed with the majority of your claim, but you've decided that a certain part isn't going to be arguable, or there are reasons why you don't want to bring it. Under Part 17, you can make an amendment to your statement of case to give effect to that discontinuance without having to make an application for permission. And then thirdly, and this really is the most commonly found example you see in practice about when the application won't be made, is where all of the other parties provide their written consent to making that amendment. And that's something we'll come to look at in a bit more detail when we look at costs, because inviting the other side to consent is an important first step in making any submissions that you want to on costs. And I should highlight, I've said I'm not going to overwhelm you with case law citations. What I have done, and these slides are going to be distributed at the end of following this webinar, is that those blue links are clickable. So if you right click, it should take you through to the case. Now, I've said that the permission might not be required, but what's important to remember is that even if the court, even if permission isn't required, the court still retains a discretion to actually refuse that amendment that you've introduced. This is found under Rule 17.2. I'll be honest, it's not something I've seen crop up all that much in my practice, but it is something to think about, because what 17.2 says is that the court can strike out cases, can strike out amendments made despite permission not having been required. And the way that that mechanism works is that if you receive an amended statement of case, you have a 14-day window within which to make your application under 17.2. It's not a strikeout application under 3.4. You can see the parallels. But what you're saying is that the amending party shouldn't have been able or allowed to make these amendments. There isn't that much guidance in the White Book about when these types of applications will be made or on what grounds they'll be made. The commentary explains that it's where the amendments, and I've got this on the slide, the amendments are shown to be scurrilous, vexatious, or to be dishonest. So that's quickly when you don't actually need to make an application. But let's say that you do need to make an application. So if permission is required, how do you go about getting it? Quite simple. Make an NT4 application. An important point to note, and something that I do see crop up occasionally, is that actually an amending party, when I'm instructed to attend the hearing, have failed to attach a copy of the statement of case identifying the proposed amendments. If you've done that, you've not got off to the best start. And to be honest, your application is probably going to face some difficulties when you come through to the hearing, because the court expects to see those proposed amendments set out, and that's provided for in the practice direction as well. Now, the second bullet point on this slide says that occasionally an informal application may be allowed. There's commentary in Part 17 making very clear that the court expects there to be formal applications. Formal applications need be made or are expected to be made. Sometimes the court allows those to be oral applications in the face of the cause, but nevertheless there's an expectation of an application. What the second bullet point is highlighting is that sometimes, and it's like very occasionally, the guidance at paragraph 63 to 67 of that case, it's a Lady Justice Simler in the Court of Appeal is explaining that there are occasions where the nature of the amendments is quite uncontroversial. It might be a typographical error. It may be that in your statement of case, there's been a reference to the wrong party. No one's really doubting what was intended. And in those circumstances, an informal application can be made, simply asking the court for permission. Now, finally, if permission is required, how do you get it? Well, quite importantly, the White Book doesn't set out any principles that are applied as to, well, what considerations does the court have when it's deciding whether or not to grant you permission if you've decided that an application need be made. Now, I promised you at the outset that, mindful that we only have half an hour, I don't want to overwhelm you with case law citation. I have rather quickly, a couple of slides in, broken that rule. And if you'll just excuse me this one indulgence, I do find that this summary, it's from the Essex County Council case, a High Court case in 2019, this summary of the general rule that's applied, focusing here not on late applications, which we'll come to in a moment, but as a general rule, the approach that the court's going to take is the parties should be allowed to amend their statements of case to bring forward intelligible and apparently credible defences where the balance of injustice to the applicant, if the amendment is refused, outweighs the injustice to the other party and also, importantly, to litigants in general, if the amendment is omitted. Now, when the slides are distributed, I've put in the notes section the links to two Bailey decisions on Bailey. One's a 2020 case, Pearce and North Hertfordshire NHS Trust. One's a 21 case, the Front Door and the Lower Mill Estate. And they're with paragraph references to a couple of summaries which have been seen in subsequent case law as being relatively authoritative and provide a nice synthesis of the underlying principles to be applied. We will canter through those underlying principles relatively quickly. You will no doubt be aware of most of these points, but the starting point for the court is to refer to the overriding objective. That's the underlying premise of all of this, is that the court is looking to deal with cases justly and at a proportionate cost. When I read out that general rule, I mentioned that there's this balancing act that's undertaken. It's a balancing act where you consider, well, what would be the injustice to the applicant if the amendment was refused, weighed against the prejudice and the injustice that would be suffered by the respondent and also other court users, because if this amendment leads to a vacating of the trial or if it has an impact on the trial timetable, that's interfering with the court's efficient allocation of resource. But what would be the injustice suffered by those other court users as well? And when it's undertaking that balancing act and when it's thinking about whether or not to grant permission to amend, the court will have at the forefront of its mind the merits of the proposed amendments. Amendments, and there is here a short citation, but ultimately amendments have to be arguable. They have to carry a degree of conviction, be coherent, properly particularised and supported by evidence that establishes a factual base for that allegation. Now, you'll see that there is discussion about this reasonable prospects of success test that can be applied. And a distinction is sometimes drawn between amendments where you're looking to introduce a new cause of action or a new claim. And in those circumstances, the court may well say that, well, then the proposed amendment needs to have a reasonable or real prospect of success, akin to the summary judgment test. If, on the other hand, the proposed amendment is simply providing further particulars, it's elaborating upon a claim that's already been made, the court has indicated that in those circumstances, you don't apply that same reasonable prospects of success test. Going back a slide, it still needs to be arguable and be coherent, etc. But you don't then go on to apply this reasonable prospects of success test. The other point to think about with this reasonable prospects of success test is that it's not to be applied when the proposed amendments are looking to reduce the number of issues between the parties or to, in essence, take issues out of the claim. So if the proposed amendment is saying, well, we're actually going to delete some of this text, it doesn't really make sense in those circumstances to be applying, well, are those is the matter being deleted? Does that have a reasonable prospects of success? The assessment has to be at the end. If the amendment were permitted, does that statement of case as it stands have a reasonable prospect of success? And I've got in blue here a practice tip. And if this I think is quite an important point. It can work both ways. If you're the applicant, it's something to think about. If you're the respondent, it's something to be alive to, which is that if you have realised that part of your claim shouldn't be proceeded, you don't think it's arguable, you want to drop it, one approach to doing so, rather than going through Part 38 and discontinuance, would be to be making amendments for it to essentially drop out of the pleaded issues. Now, if you're a respondent, you need to be alive to that, because what the applicant may be trying to do is to be getting a discontinuance through the back door without and avoiding those normal Part 38 consequences when you deal with discontinuance, where, as you'll know, the discontinuing party pays the costs incurred by the other side. So that's something just to be on the lookout for. If you see things being deleted, think about, well, are they trying to affect a discontinuance? A couple of other points on a non-late application. We'll turn to late applications in a moment. But on a non-late application, and this holds true actually for late applications as well, the amendment has to be tightly defined. As I said before, you need to be attaching a proposed copy of the statement of case. You need to be identifying the amendments, and it needs to be relative. It shouldn't be prolix. It shouldn't go on for too long. Keep it nice and tightly defined to capture the points you want to put in issue. We'll turn to late amendments now. There's a decision of Mr. Justice Coulson, as he was at the time in 2015, CIP Properties. Again, if you click on that link on the slides, it'll take you through to the case. Paragraph 19, he sets out some of the key principles underpinning a late application. Now, you can say, well, by definition, any amendment to apply is to be seen as being late if it could have been raised earlier. That's, of course, not always the case because, and this is something we'll come on to talk to in a bit more detail about costs, but if the amendment is only being made now because of matters that were beyond your control, so if, for example, the law has changed whilst this case has been ongoing such that you now have a further head of loss that might be recoverable, or a further argument that previously you couldn't advance, then that you can make an application to amend in order to reflect that. But the submission you would make to the court, and the point to make in correspondence to the other side, is this is not something that we could have made sooner, because it's not of our doing, the fact that this is now an issue. The other instance when that can occur is when factual material, evidential material comes out in the wash during the trial procedure, be that through disclosure or witness statements, or expert reports, of course, as well. And if you're making an amendment because of consequential matters that you didn't have control of, then again, you can make the submission, well, this isn't a late application. And the first point now, lateness is a relative concept. What that's saying is that when you're considering your application to amend, what you need to be thinking about is what's the overall context of the application. So firstly, how extensive is it? Is it a short point or is it a large point in terms of just the amount of text that you're putting on the statements of case? Are you making lots of changes? Secondly, what's the explanation for it? And also, what are the consequences of if this application were to be allowed? And these three things to think about, the extent of the application, the consequences, and the explanation, really echo throughout all of these applications when you're dealing with what the court deems to be a late amendment. Because as I'll come on to explain, there the burden is heavier. If you're making an application to amend which is seen as being late, you as applicant have a larger burden or a larger threshold to get it. The threshold to meet is higher. You need to clear a higher hurdle in order to satisfy the court that your application should be allowed. So the court, it's essentially seen to fall along a spectrum. And the closer you're getting to the trial date, the heavier that burden can become. And sometimes the court will use the label of it being a very late amendment. And that's seen where if the amendment were allowed, it would imperil the trial date. The remaining points on this slide, the history of the amendment and the explanation for its lateness, I've elaborated upon that being one of the key considerations, likewise the particularity. When you're dealing with late amendments, the court really puts in focus the prejudice to the respondent if this application were to be allowed, and also to other court users, because if it leads to the vacating of the trial date, then that clearly has a prejudicial impact, as parties can expect trial dates to be kept. And the other point that a respondent will make in submissions or in their correspondence when you're discussing why you do or don't accept or consent to an application is because, well, this would put us under such an onerous burden to prepare in advance of trial. So the point to make with late amendments is that there used to be a view from the courts that, well, if the other side can be compensated for in costs, then that's adequate to allow the application to go through, because we should allow the real dispute to be adjudicated upon. They have moved away from that, and you see with the illustrative decisions, which I'm not going to go into detail now on, but the courts will say no to late applications if it's simply too late and it means that the trial date will be vacated. So don't just assume that, well, because we can pay the other side's costs, consequential on this amendment, then it should be allowed through, because as I've set out on the slide, there's that heavy burden. The third point under heavy burden talks about the prospects of success. If you're making an amendment very late that imperils the trial date, one of the key points that you'll want to be making, as well as having a good explanation for why it's being made late, as well as it being a well-particularized amendment, you want to be saying the prospects of success on this case, on this issue that we're amending on, are such that it's in the interests of justice for us to be allowed to argue it. Because, and that in that point, that the fact that we would succeed, we say, on this point, eclipses the interests of the respondents and of the other court users, because it's so important that the court adjudicate on the real issues that there are between parties. If you're making an application and for a late amendment, some of the arguments that you as applicant will want to be considering and you'll want to be setting out in your correspondence to the other side is, you've been on notice. If you have, then if the evidential issues and the pleaded issues overlap with the proposed amendment, you can make the point, well, you've been on notice to these issues for a while. You're not going to suffer too much prejudice, your case needn't adapt much. The second point, does it arise out of witness or expert evidence? That's the points I've explained already about what's the explanation for why it's being made now. And the third point, well, what are the consequences of the amendment? If you say as applicant that it can be allowing this amendment, if the court were to allow the amendment, the trial could still be accommodated and the matter could still be run through within the available court listing, then that's the point to be making, is that, well, it doesn't actually mean we're going to vacate the trial date. I've got a practice point again on the slide here about check with listing about availability. Cuts both ways. If you're applicant and you say, well, we want to make this amendment and it's going to mean that we need an extra day with the court for the trial, it's important that you've got the ability to say to the court when you're making your application, oh, and by the way, we've checked with listing and listing say that it can be accommodated. Likewise, if you're responding and you say it's going to need more time at trial, you'll want to check with listing, because if listings say we wouldn't be able to accommodate an extra day in the court listing, then you'll be making that point to the judge saying, well, it will lead to a vacating of the trial. I've got an authority at the bottom of the slide, PJSC TAP-NEFT. Now, that link there is through to a Westlaw. It's a Westlaw link as opposed to a Bailey link, because the case is quite hard to find on Bailey. But it's an important authority to have if you're making a late application where you don't really have the best explanation for why it's being made now. There's this fresh eyes justification. Essentially, we've got some new lawyers on the case, or we've instructed counsel rather late in the day, and they've spotted the point. Now, sometimes the court may say, well, that's simply not good enough. But what the authority is helpful for, Mr. Justice Jacobs is saying, the absence of a good reason for the delay is not fatal to your application. So if despite that, you can still satisfy the court on that balancing act of the relative injustices, then that doesn't mean the fact that you're only noticing it because counsel has been instructed late doesn't provide the knockout blow that the respondent thinks it may do. And now I'm looking at the time, and I do want to talk about costs, so we'll be relatively quick here. I've got another couple of helpful summaries of the principles to apply when you're dealing with late amendments. They're not particularly long. I would suggest that you read, it's a paragraph from a 2015 decision and then an annex to a more recent commercial court decision. In the commercial court, and I've got a reference to the commercial court guide later in my slides, there's a slightly different approach taken. And you'll see that the starting point with a commercial court assessment is that late amendments should be avoided, and they may be disallowed even if they don't imperil the trial date. So you can see the court's starting assumption there, albeit the court, as we'll come to see, expects parties to deal with the matters by consent. So what to do if you've made an application and it's been granted, or if you're in the process of making the application, the practicalities of how to go about making the amendments. I've set up on the slide. There's a presumption, or not a presumption. I often find that parties seem to think that they have to keep the old text. That's not necessarily the case. And then you don't have to unless the court orders that you do. And if you're trying to amend you don't really want anyone to be reminded of what you set out previously, that would be an instance where you don't set out the old text. The amendments can be in different colours or different typefaces. There are references to the practice direction, which explains the different approaches you can take. You'll find that parties often are on the side of using different colours, but the important point to actually remember is that you may be dealing with courts where they don't have colour printers, which it's a relatively practical point, but the judge, I've had it at hearings where the judge says, well, I can't see what the amendments are because it's hard to tell where the different colours are. Now, that's all relatively practical stuff. This, again, don't forget, these are, again, practical points, but I do find that they're sometimes missed, and that's why I think it's important to highlight them. Don't forget that you do need to update, when you're making an application to amend, you have to update the title of the document. And the practice direction explains that title will either be it's amended pursuant to an order of, and you insert the name of the judge, or if you're amending without needing the court's permission, you say, well, it's amended pursuant to and the particular revision of Rule 17.1. That's the first point that no one should forget when they're amending. The second point is also to update the statement of truth. You need to re-verify the document, and so you'll have to update the name of the document that you're verifying in your statement of truth. Now, if you're a claimant and you're applying to amend, it is important to remember a couple of other points. If you're amending and you're bringing a new cause of action, remember to update the prayer as well. I've seen that forgotten. Also, remember that you may also need to update your claim form at the same time. It's a relatively minor, you might regard it as being a relatively minor point, but it is an important point that in your brief details of claim and your claim value, that will need to change. And also as well, you need to indicate that you'll pay the increased court fee if there is one. If you've not already come up to that £10,000 cap for issuing, then you'll need to set out in your application that if this application is successful, we will be paying the increased court fee. If you're the defendant and you are seeking to amend your defence, do also think about your acknowledgements of service, and it may be that you need to amend there as well. The one point to mention there is that an acknowledgement of service isn't actually recognised or defined as being a statement of case as defined in the White Book under Rule 2.3. So there is a case, but ultimately you ask the court to give you permission to amend under its general case management powers under Rule 3. Court-specific guidance, the only key points to highlight here are that if you're in the Chancery Division in the King's Bench Division and you're seeking an order for permission to amend, do have a look at the standard form draft orders. And I've got links to click through to there. If you're in the commercial courts, do read paragraph C5. It's not a long one. What it explains is that in the commercial court, you've got to keep the original text unless the court orders otherwise. The court expects parties to deal with amendments wherever possible by consent. And there's also an indication that respondents should set out their objections if they do advance them in writing in advance. The intention from the court is clearly to try and have these matters dealt with on the papers by consent. I'm conscious of the time, so it may be that some of you need to get on with your days, but for those of you who can stick around for another couple of minutes, we'll talk quickly through costs, because this is an area that gets a lot of focus in these applications. So the starting position when making an application for permission to amend is that if you're successful, the applicant will usually be ordered to pay the costs of an occasion by the application. That position is set out in the beginning of the practice direction. There's a decision of Mr. Justice Mann It's a 2021 High Court decision, Various Claimants and MGN Limited. Now, what he says there is that having looked at the cases and gone through the principles, he couldn't find any principle articulated in the authorities as to why that rule was adopted. And his explanation was that, well, if the applicant has of its own volition changed its tack in the litigation, and the respondents therefore have to go back and do more work as a result of it, then it's right that the applicant should pay those costs of doing so. So that's the normal rule, which you may find yourself struggling to argue against. That doesn't mean you can't argue against it. And when thinking about the arguments to be making against that rule, you need to draw the distinction between the cost of applying for the amendment, cost of doing the application, and the costs of the amendments themselves. As regards to the cost of applying for the amendment, respondents, it's recognised, shouldn't oppose applications tactically for strategic reasons in order to put pressure on the applicants and to drive up costs. That decision of Mr. Justice Foxton, what he explains in there is that the principles regarding amendments are now relatively settled. People are able to apply them. And given the clarity underpinning those principles, parties are expected to consent to limited amendments, which can comfortably be addressed at trial, and they shouldn't act unreasonably. And the point that you would make as applicants is that if you think the respondents are acting unreasonably, then such that you're forced to make an application, when it comes to submissions on costs at the end of that application, if successful, you'd say, well, the respondent should never have resisted this application. We only brought it because they were acting unreasonably. So that's in the correspondence. If you're acting on behalf of the applicants in advance of filing your application, that's where you try to exert some pressure. You can have reference to that case and you can say, if we're forced to make this application, we'll be seeking our costs from you. The costs of the amendments themselves, the first point to think about here is that those costs can be quite extensive. And when you're thinking about whether or not to make your application to amend, you need to be talking through the clients. It may be that the nature of that amendment is such that it's just so critical that it's brought into the litigation, and the client is therefore willing to pay the consequential costs. But when thinking about what those consequential costs may be, there's of course the costs of amending the statements of case. So the respondents will have to amend their statements. Then, depending on what stage of the litigation is at, there may be costs consequential on the amendments in amending witness statements, in amending expert evidence as well. You may need to go back to the experts. If the costs are being made so late that the trial date is being vacated, there may be costs thrown away as a result of vacating that trial date. And it may be that if it leads to an extension in the trial length, that there will be costs caused because of it. Now, in those cases, particularly with the costs as a result of extending the trial length, if you as applicants, if you're the applicants in that case, the submission you want to make to the courts is that they should be costing the case, rather than it shouldn't be the case that the respondent should be entitled to all of the costs consequential on a longer trial date if the extension in time pertains to matters that you do ultimately succeed on. But when you're thinking about the possible scope of costs that you could be liable for of an occasion by the amendment, some of the heads of cost that you need to have in mind. If you want to argue against the usual order, we've talked about the cost of applying for the amendments. In terms of the cost consequential on making the amendment, you really have reference to those points that I explained earlier. What's the explanation for this amendment? Has it been brought about because of something that's come about in the respondent's disclosure or the respondent's witness evidence? Has it been brought about by a change of the law outside the scope, independent of this litigation? If it has, that's a submission to make. it's also important to act quickly. That Lend-Lease construction decision there, the court took the view that, well, whilst the amendments were as a result of things done by other parties, if you then don't act immediately, those other parties may well assume that their matter is proceeding as was, and that there's to be no change in the scope or the nature of the issues in dispute. So if you find out issues in disclosure, you don't make your application to amend there and then. You let witness evidence and experts evidence go through, and then you decide to amend. You're putting yourself, while you might have had a good point to make if you'd acted quickly, leaving it too late means that that argument is taken away from you. Cost budgeting. Remember that if this is a case that's been cost budgeted, then depending on the nature of the amendment, it may be that you also have, and the budgets have been approved, if you're post-CCMC, you may need to seek permission to amend the budget as well. And then finally, the mop-up slide. If you make your application applying the principles we've set out, the court allows it. The consequential matters that the court's going to have in mind, 17.3 says, well, the court will be making orders about the service of the amended statement, having made those changes we've highlighted, but also the consequential amendments to other statements of case. And then if it's necessary, you'll need to be dealing with the amendments to the witness statements and also to the expert evidence. If that amendment has been allowed, I've got on the slide to think about reallocation. Depending upon the stage that the proceedings are at and how the value's changed, you may feel that this is a matter that needs to be changed from, for example, a fast track to a multi-track. If that's something to draw to the court's attention, to be honest, it may err the court away from allowing the amendments because if this amendment is allowed, it means that the matter goes to the multi-track, and if in the court that you're in, that then necessitates cost budgeting, etc., then that is an instance, that's a factor that goes into that overall balancing of factors. And then a final point is a practice point: keep the wording of the order tight. Don't sign off on a blank check. What I mean there is, in particular, if you as applicants have succeeded in getting your amendments through, because the respondents are going to be entitled to amend their statements of case, I've seen it happen quite a lot where parties are very happy to just say, well, the respondents have permission to amend 14, 28 days thereafter. What I always advise is that you actually say in those amendments should be restricted to the scope of, or be amendments in respect of or consequential on the amendments that the applicant has been allowed to make. So you don't want to be giving the respondent the opportunity to say, well, we've now been given an order which simply says we can amend our defence, for example, within 14 or 28 days. You don't want them to raise new defences which don't have anything to do with the amendment that was permitted by the court. So I am conscious of the time, and given that, I am going to call things to a close there. If any of you have any questions, then don't hesitate to get in touch. You've got my email address there, and enjoy the rest of your days. Thank you very much.